What are the tools that you need to set up your estate plan? It can be a long, confusing journey. And we are very lucky to have attorney Joseph Marra here today to help explain what we need to know to set up the right estate plan. What are the documents you need? What are the pitfalls? He's going to help answer the questions for the residents of New York. Enjoy this video.
What tools do you really need in order to do your estate planning? Well, there's certain basic tools, no matter where you're located, that you will need. First is a power of attorney. Second is a healthcare proxy. A third is a living will, and then the last is a funeral directive. Well, let's talk first about a power of attorney. What does that do, right? Power of attorney allows you to give someone the power to handle your financial affairs in the event you can't. And it's a very powerful tool, but remember, it only relates to financial matters in New York. Some states are different. They put together various documents or various powers in one form. In New York, we don't. They're divided up. So the financial one in New York is the power of attorney, right? And well, when does it become effective? Basically, it becomes effective when it's signed and when the agent signs it. What do I do with mine? I normally suggest that you name two people as your agents, two people who can handle your finances, and a third person who could only step in if those two people cannot. Now, remember, as soon as you are, I know I stopped sharing the screen for a moment. So as soon as you sign that power of attorney, you give someone the power to manage your affairs. Some people don't like that. They're like, well, wait a minute. What if this person's going to steal my money? Well, here's my answer to you. Number one, pick wisely. Number two, there is something, at least in New York, I don't know about other states, that we call a springing power of attorney, which only takes effect if you're disabled. So if you say, oh, great, I'll take that. You know what? I will not draft that. Here's the reason why. Think about it from a practical term. Number one, you now become disabled. You have this document that gives someone the power. Then have to go to your bank or a brokerage account or wherever and prove that you're disabled. How are they going to do that? Well, they're going to need a letter from a doctor. Do you think doctors really want to prepare such letters? They don't. And even if they do, they're in the proper format of the financial institution, who knows? So I tell people, let me prepare the document, deliver it to your financial institutions, they may require your agent to sign something, have them sign it, have it all there so your agent can act. But what if your agent does something wrong? Well, wouldn't you rather know that where you're competent in catching them and you could put a stop to the power of attorney because you can cancel it at any time? I'll tell you a story that I heard from a colleague. This woman, not married, no children, lived in New York County, Manhattan, and she had to go in for some surgery. And she said at that point, well, I'm going to do some estate planning. So she named her sister, and who also happened to be her best friend, as her agent. And then she went in for some surgery, and she basically was out of commission for about 4 weeks. When she finally regained her faculties and went online, she found that her sister took $40,000 and blew it in Atlantic City. So do we want that? No. What if she was competent when she'd given the sister the power and the sister had taken some action? She could have stopped it right away. And also, I think psychologically, if someone knows they have the power for a long time, they're not going to really abuse it. I just think that's psychologically how people work. So you are giving up a lot of power. I tell clients, look, you're signing this power of attorney, your son, your daughter can take all your money and run away to Bolivia if they want. And they can. But remember that agents under a power of attorney are under the highest fiduciary standards, and they can be and have been criminally prosecuted for abusing their powers. So I think it's a good idea to choose your agent wisely and give them the power. Now, some people think that after someone dies, they could still use the power of attorney. No, that's not the case. The power of attorney ends on death. So it cannot be used after death. So once again, manage your financial affairs, use while you're alive. You can cancel it at any time, okay? Looking at the outline, most of this we covered. You're granting someone authority to act for you, all right? It can be limited or broad. The power is, but I make mine very broad. I give someone the same power you have. The only exception to that is sometimes in real estate transactions, if someone can't attend a closing and they want to give either me or someone else the power to handle a closing for them, that's when we make it limited. If not, I recommend being as broad as possible. Right? This year, June 13th, New York State enacted a new form power of attorney. So people ask, well, what about my old power of attorney? Is it still valid? Yes, it is. If it was signed before June 13th, it's valid. There was also a major change in 2009 and 2010. Now, as a practical matter, if you have a power of attorney from 2008 and it's been sitting in your drawer and you never gave it to a financial person, well, if your agent 3-4 years from now needs it, you're going to have a problem. So what I would tell you to do, if you have an old power of attorney and you haven't given it to the financial institutions, do so. They may want you to draft a new one. Technically, they're not supposed to, but you have people who are looking at things and they know it's valid now. The law is, as long as it's valid at the time it was executed, in the state it was executed, it should be recognized. Does that work as a practical matter? Always? No, it does not. Now, some people might ask, well, wait a minute, I drew up a New York power of attorney and I moved to Florida. Once again, the state of Florida, they're supposed to recognize it as long as it's valid in the state where it was drafted at the time it was drafted. But once again, as a practical matter, you might want to get another power of attorney drawn in Florida, just for practical reasons. There's the legal and the practical, and they sometimes don't always mesh, all right? As I said earlier, goes into effect immediately, can be revoked at any time, automatically revoked on death. What are the disadvantages? Well, obviously, the advantages and disadvantages are like two sides of a coin. Advantage, some power can act immediately. That could also be a disadvantage, right? The effect of a cancellation can be problematic if you don't provide proper notice. So agents are required to sign it before it's effective. Another problem that comes up, what if more than one power of attorney is executed? Well, generally speaking, unless you specifically revoke a power of attorney, it's in effect. So if you have executed a power of attorney and you don't want that power of attorney in effect, merely signing a new one isn't going to help. You have to revoke that one, send notice to the agent, send notice to whomever you've given it to, and that's the way you revoke it. Right? There's something called an affidavit of full force and effect. I mean, I put it in my powers of attorney and people say, should I fill this, have my agent fill it out now? No. Every time the agent uses the power, they're supposed to fill out an affidavit of full force, which basically says, one, the principal's still alive because, as I said, it ends on death. Two, they haven't revoked it. Three, you see no reason why it can't be used. So that's the affidavit of full force and effect. So to summarize, power of attorney only relates to financial matters, goes to effect immediately upon being signed. You can revoke it at any time. It ends on death. Those are the basics of the power of attorney document. As I said, in New York State, it only relates to financial matters. In other states, they put it together to do other things, which now we're going to dovetail into. Healthcare proxy, living will, and funeral directive. New York has 3 separate documents for those, I should say. In other states, New Jersey is similar. Other states have them all in one document. I know for a fact Colorado has them all in one document. Depends on where you are. But in New York, it's separate documents. In New York, the healthcare proxy is statutorily the operative document under our general obligations law. And what does it do? It goes into effect when you cannot make your own medical decisions, okay? So as soon as you're deemed incompetent to make a medical decision by a medical service provider, your proxy can now make medical decisions for you, right? So look at the contrast with the power of attorney. Power of attorney goes effect immediately on signing. Healthcare proxy does not. Power of attorney relates only to finances. Healthcare proxy relates only to medical issues, right? Can both be revoked? Yes, at any time. Another thing you should consider, New York State presumes that everyone wants life-saving means, artificial nutrition, hydration, no matter what, okay? And there's something called a do not resuscitate order. Now, a do not resuscitate order is an order signed by a doctor that says do not resuscitate. If this but what happens if someone's in a hospital and their breathing is just fine, but they're brain dead? Okay. Well, if they haven't signed a healthcare proxy, they have to be continued to be supported. It's only if they can no longer breathe that they can let them pass away. So don't get confused. Do not resuscitate order is something signed by a doctor in the hospital. It relates strictly to resuscitation. Healthcare proxy gives someone the power to make medical decisions for you. Now, some healthcare proxies say, my healthcare proxy knows what I want. I don't like drafting them that way. I like drafting them in conjunction with a living will. Now, what is a living will? It is a declaration or a statement that says, basically, look, if I'm brain dead, pull the plug. No food, no water, just give me drugs, no pain. Other than that, pull the plug. And I take the language from the living will and also put it in the healthcare proxy, so they're consistent. And my healthcare proxies and living wills have been honored by numerous hospitals. As I said, there's a statutory form. Sometimes hospitals like, here, fill this out. Well, they're okay, but I find a lot of people don't put their specific needs. They mess up the form. They also don't put a successor agent in, which is very important. If you're naming your spouse and you don't name a backup, which I usually name two, what if your spouse is incapable or your spouse has predeceased you? Then what? It's useless. So once again, have a backup plan, have a backup in the document. Funeral directive, very simple. We allow this in New York. Allow someone to make your funeral arrangements for you. That's particularly relevant if you have no children, maybe have no close relatives, and you want to name a friend to do that. Gives them the authority to do that. So pretty important.
Thank you so much for listening to our video. If you have any questions about the information that you've heard today, please don't hesitate to contact the law offices of Joseph A. Marra. They are experts in what they do and more than willing to help you get the right strategies in place so that your estate planning makes sense and that it works the way you need it to. Thank you so much, and we'll look forward to hearing from you.